Hello everyone, I am Lavanya Deshmukh, the technical coordinator for this international symposium and also the student of Shri Shivaji Science College, Nagpur, India. Distinguished delegates, esteemed scholars and colleagues. It's a distinct honor to introduce a towering figure in the legal academic community and a vital leader in the promotion of intellectual property and research excellence. Today, we are privileged to have her lead our discussion on the development of patent law in India. Please join me in welcoming Dr. Payal Thaorey, Assistant Professor, Selection Grade and Senate Member at RTM Nagpur University, a recognized PhD supervisor at the Dr. Babasaheb Ambedkar School of Law. Dr. Thaorey's career is defined by a deep commitment to both the theory and practice of law. With over 15 years of experience, her leadership role have been transformative, most notably as the former head of the department at Postgraduate Teaching Department of Law and her influential tenure as the chairman of the Board of Studies in Law. Her academic journey is marked by excellence, having earned top honors in both her LLB and LLM studies. She holds a PhD in law with a specialized focus on cyber law and cyber crimes, an area where she continues to be a leading voice today. Dr. Thaorey's impact transcends traditional academia. She is a recognized international expert having complete high-level consultancy project for the Rolls Wallenberg Institute in Sweden, including the development of a model handbook for local government on the implementation of sustainable development goals regarding environment protection and gender equality. Her global reach is further evidenced by her invitation as a panelist for the Regional Dialogue on Human Rights in Manila, Philippines. Her commitment to innovation is equally profound. As the coordinator of the IPR cell at ITM Nagpur University and a certified expert in copyright from Harvard Law School, she is a fierce advocate for the intellectual property protection. Her expertise in this field was officially recognized by Ministry of Human Resource Development, Government of India for her instrumental work within the University Innovation Cell. A prolific research and dedicated mentor, Dr. Thaorey had published over 50 research papers and has hundreds of students, including those currently pursuing their doctoral research under her supervision. Her career is a testament to the idea that law, when combined with dedicated research and innovation, serves a powerful instrument for social and global progress. We are truly honored to have her with us to unpack the complexities and historic milestones in the development of national patent framework. Please join me in extending a warm welcome to Dr. Payal Thaorey.
Greetings to you all. Welcome to this session wherein we will be discussing about the development of patent laws in India. But before we begin, let me share my screen. I hope this is visible. So here we will be discussing about the development of patent laws in India. Now, as we all are aware that India was always an extraordinary center of learning for several years. There are a lot of ancient texts wherein we have seen a significant knowledge has been created in the field of science, in the field of art, in the field of literature, in the field of yoga, wherein these ancient texts provide evidences that we have developed knowledge in almost all the field. However, the cultural practices in India restrained us from monopolizing it. We always believe in sharing. We always believe in sharing the knowledge with all and sharing the knowledge for the betterment of mankind. And that is how we restrain ourselves from monopolizing it. Because we know that sharing does not require any sort of consideration. But with the advent of industrial development, we started identifying that there is a nexus started developing, between the inventions and the economy, and that is where the world at large, identified that these knowledge creation with the help of intellectual, mind needs to be encashed, it needs to be protected in the form of intellectual property rights. And that is how protection of intellectual property rights begin. If we want to talk about origin of patents, then the formal documentation of grant of patent can be traced from the early 1300, wherein a special privilege was granted in the form of letter patent. The British sovereign used to grant a letter to any person, who is going to produce unique music, unique bakery product, unique painting, unique culture or a piece or art. So that is how these type of letter patents started giving them a monopoly right. Then later on in the year 1409, the first patent was granted for the construction of model mill, wherein exclusive monopoly was granted. Of course, it was the French sovereign who started the process of registration and examination of patent, and then they started giving the letter patent. The Indian patent system is completely influenced by the British patent system. Needless to say that we have been ruled by the Britishers for over 200 years, and we have seen that the whole legal system was developed, to a very good extent by the Britishers. And that is how even the patent system got its reflection from the British. Now, these are the various types of intellectual property. There is copyright, trademarks, industrial design, traditional knowledge, trade secrets, geographical indication, and patents. So, today's discussion, we will be confining it only to the development of patent law. Basically, these are the 7 oceans of IP, and today we will be discussing the patents. Now, what is patent? Basically, patent is nothing but an exclusive right granted for an invention to the inventor by the sovereign, basically by the government. It is a type of intellectual property that gives the owner every right, or rather every legal right, to exclude others from making, selling, or using the invention for a limited period of time. Now, if we see the development of patent law in India, then we can see that it has been classified into 3 parts. The part 1 of patent law deals with the development in the colonial period, that is the period when Britishers used to rule India. Then the second part deals with the post-independent period, wherein we begin from 1947 onwards. And the third important development took place from the time when globalization started, and that is the part 3, that is WTO onward. So we will be looking into this discussion one by one. So if we want to discuss about the colonial period, then there were series of enactments which were there, which was influenced by the British. And the first law which we got in India about the patent was the Patent Act 1856, which was again based on the British Patent Act 1952. Here, along with the letter patent, the monopoly was granted for a period of 14 years. So a time frame was decided. Later on, this act got changed, or we can say there was an amendment in the 1859 Act. And here, not only the monopoly right, but at the same time, exclusive making, selling, and using of that invention right was granted to the patent holder. At the same time, the 14-year term was counted from the date of filing the patent specification. So these were the changes which were incorporated in the 1859 Act. Later on, in the year 1872, this Patent Act was renamed as Patent and Designs Protection Act. The reason being that designs were included into it. Earlier, it was only invention, but 1872 Act does talk about design, industrial designs as well, wherein a patent has been granted to design. The significant development in the colonial period took place in the year 1883. Now, in the 1870s, almost like everybody knew at that time that Germany was evolving as a developing nation and industrially sound nation. And that is why, whenever there were exhibitions, other countries started restraining themselves to put forth their invention in such exhibition, because they all were scared that Germany might start imitating their invention, and that is why they wanted some exclusive protection from their for their invention. And this is when this Paris Convention took place. Now, Paris Convention talks about protection of patents and industrial designs, particularly related to invention. And that is how the 1883 Act was again renamed as the Protection of Invention Act. One more significant development which took place in the Paris Convention was the formation of United Nations Bureau for Intellectual Property Protection, that is BIRPI, which is a predecessor of WIPO. Now, after this 1883, now one more significant development in the 1883 convention, which took place, was that they started identifying that intellectual property rights are basically the moral right first, and then they are the legal right. That means the protection must be granted on the basis of first come, first serve basis. So whosoever has invented it first must get the protection first. Later in the year 1888, this act was again renamed, and now they started combining inventions and designs all together and started protecting both of them. And then finally, in the year 1911, we got the Indian Patent Act, which is again the predecessor of the Indian Patent Act 1970. So this is the landscape, legal landscape about the patent laws which were there in the colonial period. Of course, it has a significant place in our history that it started providing us a landscape that whatever inventions we are doing in India, they all are eligible to get the patent protection. During this time, as we all are aware that already World War I has taken place, and later it was World War II. And we all knew that it has its own after effects. So almost everywhere the economies were collapsed. So the United Nations organization established three institutes, particularly the World Bank, the IMF, and the ITO, for reviving these collapsed economy, particularly for the developing countries. For the International Trade Organization, the USA blocked it, and further there was no such work done in this arena, but the World Bank and the IMF continue to contribute towards developing the economies. And that is when this general agreement on trade and tariffs took place, which was there basically with the sole purpose of liberalizing the trade so that we all can combat with the aftermaths of the World War, and of course to develop a very amicable multilateral trade negotiations so that there will be smooth exchange, smooth export and import of the necessary goods and materials. And of course, one more thing which was added on with this GATT 1947 was setting the interstate dispute so that the trade should not get disrupted because of this dispute. So India signed the GATT and ratified it and became the member of it. Later on, in order to promote the international cooperation and particularly protection of works of human minds, which are in tune with the socio-economic and cultural progress of all. I'm talking about all the developed, developing, and the underdeveloped nation. There was a requirement that we must have some set uniform norms, standards, practices in order to register and recognize the intellectual property. Now, what has been happening, that the developed were becoming more developed and the underdeveloped countries were still struggling with the revival of their economies. And in order to provide a platform wherein all the inventions, all the developments will be shared, of course, with a protective mechanism, there was a requirement that these principles, these standards must be established. Then that is how this particular concept of patent cooperation treaty came in. So the WIPO, that is the World Intellectual Property Organization, worked exclusively for setting up these international standards, so that anybody, suppose an inventor is there from India, and if he wants to register his patent in Germany, then WIPO can provide that uniform registration mechanism, wherein through PCT, that is the Patent Cooperation Treaty, he can approach for international filing and get his patent filed there. So WIPO made this Patent Cooperation Treaty in 1970, and this is how the international like standardization of intellectual property took place. India is a party to WIPO. We do have ratified it, and we follow all the guidelines issued by WIPO for the protection of intellectual property in India. Similarly, the parallel development which took place in the year 1947, as we know that we got our independence and we were free from the clutches of British rule. And the very first thing which the then government of Pandit Jawaharlal Nehru did was identified the potential of intellectual property protection. So the first thing what he did was the appointment of the Bakshi Tekchan Committee 1949 for understanding the nature of protection required for intellectual property in India. Later, it was followed by Justice N. Rajagopal Iyengar Committee in 1957. Both these committees, Tekchan Committee and Rajagopal Committee, both these committee basically evaluated the socio-economic, cultural, and educational status of India at that time, the requirement, or we can say the need of the people at that time, and the resources and the technology what we had, and accordingly they identified that what sort of patent protection we should give. Similarly, at that time, we were already in the process of making of the Constitution of India. So we have recognized the right to property under Article 91F. Of course, later on, it was removed in the 44th Amendment, but that right was identified as a fundamental right. Of course, that has a restriction of removal of property with the authorization of law, but otherwise that was a fundamental right given. And then we had, of course, directive principles of the state policy, wherein it is the responsibility of the state to provide facilities so that we can develop we can get into this process of development through technological interventions, through scientific tempers, through lot of infrastructure and other efforts, wherein intellectual property can be developed. And if we refer the fundamental duties 51A, then it does talk about promotion of scientific tempers amongst all. So all these things makes us provides us a platform wherein we can say that development of intellectual property is constitutionally valid in India, because we have done a lot of work wherein this has been identified. The Indian Patent Act 1970 is one such development. The Indian Patent Act 1970 is one such development which is very significant. Now, we know that in 1970, we already were party to Patent Cooperation Treaty, and that is done through WIPO. And at that time, we had our Indian Patent Act 1911, and we had the reports of these two committees. So, based on these two committees, the first thing we did in the Indian Patent Act was that we started identifying that patent can be given not only to the product but at the same time to the processes which are unique processes which does contribute in an economic way to the inventor. So this is one such leap, which we took, that is not only the product, but now the process also started getting patent protection in India. Now, patent rights are granted for inventions covering a new and inventive process, product, or an article of manufacture. Now, the other things, that is the novelty, inventive step, capable of industrial application, must be read along with the written description and non-obviousness. So, the domain, under which the patent protection was granted was enhanced, not only the novelty and invention, but industrial application, and must be followed with written description and something which is non-obvious. Of course, there are certain exceptions to the patents, particularly if we refer to section 3 and 5 of the Patent Act that was mentioned, wherein a plant, varieties, medicine, drugs, not exactly medicine, plant varieties, drugs. These were all anything which is related to human health was restrained from getting patent. Anything which is in tune with nature, like something which is produced by nature, was restrained from getting into patent. And later on, there we have seen there is a lot of development in this exception, and now we have um, patents for microorganisms as well. The Patent Act 1970 was repeatedly amended in 1999, 2002, 2005, 2006 because we were signatory to WTO. Now, when we were having, like, now we are into, let us say, 1980s. So at that time, it was identified that even though lot of international trade negotiation were going on, but because of the competition, because of the tariffs, and because of the exponential technological development, there was a huge gap between the developed and the developing and the underdeveloped countries. And that is when these early rounds of negotiation took place. Now these negotiations were done basically to find out that how the trade can be promoted. And the negotiation, like the conclusion of those early rounds of negotiation was that we must establish WTO, that is the World Trade Organization, which will work for the upliftment of trade, functioning of international trade, and for providing economic benefit to all. So with this motto, the World Trade Organization established. So we can say it is the successor of GATT, and WTO not only had GATT, but it also has GATS, that is the General Agreement on Trade and Services, and TRIPS. So TRIPS was basically the trade related intellectual property protection. So when it comes to, like, for example, bilateral market sharing agreements within the competitions, it was realized that regionalism was taking place, like Northern America, Southern America, SAARC nations, a lot of regional agreements were there. So in order to provide them a safe market at the global level, WTO jumps in, and this WTO started providing a safe trade zone for the member states. Now, the moment we talk about WTO, automatically that was the time, it is under the Narsimha Rao government, that time we entered into globalization, liberalization, and privatization. Now, which means that we started opening our doors for trade with foreign countries, wherein we were not providing them limited access via license, but we started entering with competition and fair play. So these type of, like, the WTO agreement, which is also known as the Marrakesh Agreement, took place in January 1995, and India was a signatory to it. So the very first thing which WTO works on with the two principle, and they are the national treatment and most favored nation. And both these principle talks about one thing, that treat the foreigners and locals equally. Means, for example, whatever protection we are giving to local inventors, same type of protection we need to give to the foreign inventors. So this is how it started beginning. And then the WTO also talks about fair competition. That means in this competitive world, whosoever is best, whosoever understand the needs of the consumer and provides the services as per the consumer requirement, will certainly sail through in the competition. And then there is free trade. Means there should be no trade barriers. If there are tariffs, then they will be same for all, irrespective of whatsoever region you belong to, or whatsoever country you belong to, but that will be a free trade. And certainly this approach of WTO was made with the sole intention of encouraging and developing the encouraging development and providing economic reforms to all. Now, TRIPS is the most significant development when it comes to patent laws in India. It has been provided under the Annexure 1C of the WTO agreement, and it provides standards and protection of intellectual property. It also tells us that we, for example, countries like India, which are agriculture, like who is an agricultural country, must have some sui generis law, that is like self-made laws, wherein we can protect our own agriculture products. So that provision has been provided to us under the TRIPS. Now, TRIPS also specifies enforcement procedures, remedies, and most importantly, the dispute resolution processes for any dispute occurred for intellectual property. TRIPS covers all types of intellectual property, right from patents till geographical indication, trade secret, etc. Of course, TRIPS also provide developing countries with some extra time to implement the applicable changes to their national laws in two tiers of transition according to their level of development. Now, TRIPS came, let us say in the year 1995, it came. So it gave us a buffer period of 10 years, that is till the year 2005. We had 10 years of time wherein we can amend our existing intellectual property laws and made them in tune with the international standards provided by TRIPS. Now, what is going to happen? What happened with this is that we became at par with the international standards, and the process started becoming smooth, and lot of international inventors started coming to India, and vis-a-vis. Means India also got opportunity to provide their inventions, to register their invention in the foreign land. While this looked a very good picture, that yes, WTO, we are member, and then we are having international trade, etc., etc. But during that phase, India faced a major setback, and that is, we can say, a learning lesson, in the patent history of India, and that was the turmeric case. Now, turmeric case, it happened in the year 1995 when the United States Patent Office awarded patent to the University of Mississippi for identifying the novel feature of turmeric, that it can be used as an antibiotic. After 2 years, when the CSIR in India and got to know about this, so they filed a petition, and then they provided lot of evidence wherein they showed that haldi, that is the turmeric, is a traditional knowledge of India, and in India we knew this, that haldi has antibiotic properties is known to everybody, and that is why there is nothing which is novel, and because there is no novelty, you cannot grant any sort of patent. Eventually the patent office in USA withdraw that patent, but it took us lot of millions of dollar to spend on, for protecting this turmeric. Similar type of situation we faced when there was this grant of patent for basmati rice as as a type of long grain rice, but again India filed a petition and provided all the scientific evidences that this again belongs to us. Then the third example is of neem case, wherein the Department of Agricultural in USA applied for patent for the properties of neem, that how it helps in enhancing the health of an individual, and then the Indian government filed the opposition for the grant of that patent, and eventually even that patent has been withdrawn. We have multiple examples. There was this same thing happened with ginger, with amla and tulsi. So these were the lessons which we learned, and that was the time. That means at one hand we were entering into globalization, becoming part of WTO, opening our doors to the international domain. At the same time, we started identifying that this is not good. Everybody else is, getting patent for whatever prior art or traditional knowledge we have, and that is when this thing that now India wants to be aware about its intellectual property begin, and we started taking lot of efforts in protecting our patent by developing our patent law which can combat all such challenges. So these are the three major amendments which took place during that buffer period of 10 years. The first amendment which we saw is the year in the year 1999. That was this provided us with the mailbox facility for patents, product patents, particularly for medicines and drugs, because these were earlier not allowed. But now the new development in patent law allowed us to have patent for this, but this will happen only after a period of 10 years. That is after 2005. But till that time, a mailbox facility was provided that you can send your patent application, and then it will be considered after the end of the buffer period. So this facility was provided. And one more thing, that for those products, wherein mailbox facility was used, exclusive marketing rights were given, that till that year they can at least market their product, and if they get a patent after like 2005, it is okay. But if they don't, but still they have that marketing right till that period, until they get their patent rejected, and they can encash the benefit of the invention which they took place. So this is one of the major amendment which took place in 1999. The another development happened in the year 2002, wherein the term was extended from 14 years to 20 years, and then the provision of compulsory licensing was also enhanced here, wherein in case if the government feels so, in case of any emergency, or sometimes even if people feel on their own that my product should get compulsory licensing, then they all can come together, and the compulsory licensing can be processed. Then the next amendment was the exclusion from patentability. Now these this development was precisely made clear, considering Section 3 of the Patent Act, that what needs to be excluded and what needs to be included when it comes to the patent protection. And then this bipolar was also introduced as a part of amendment in the Patent Act 2002. The next amendment, which took place in the year 2004, of course, it got executed in 2006. That is, they started recognizing the Budapest Treaty. Now, Budapest Treaty was related with the microorganism, deposition of microorganism for examination, and that was considered in 2006, because the 10-year buffer period was already done with. The exclusive marketing right provisions which were given, that were removed, and then the process patents were also encouraged. Okay, so this was a very significant development, because it helped the whole pharmaceutical industry. That process, now the same medicine can be produced economically, considering the Indian requirement, considering the Indian surroundings, and this was a major hit. It enhanced the pharmaceutical sector. Similarly, there are other various developments which are very significant when it comes to patent laws in India, particularly the Novartis AG versus Union of India case. It took place in 2013, wherein the Supreme Court of India precisely said that there should not be any evergreening of patent. That means once a patent is granted, it is there for a very, very time, and then you are like not allowing any new or any peripheral development in it, and that is where it restricted, that we need to allow such development and let this invention grow and reach to those who are in need, rather than confining it and saying that all the peripheral development also become part of that invention. So this Novartis helped a lot, and this also again enhanced the pharmaceutical sector, the generic medicine sector, because lot of cost effective medicines started producing later. Then the court also has shown its flexibility towards applying dynamic injection when it comes to patent infringements in India. Particularly, dynamic means that today they might give you one sort of remedy, but today if the court comes to know that this was less, then they might grant more remedy eventually. So this is how this dynamic injunction works. Of course, there are a lot of changes in the patent filing process. Earlier, the process was quite rigid. At the same time, the time required for examination and opposition was big enough. But now with this technological development, immediate tatkal filing of patents and everything has started, so filing process have become easy. At the same time, for example, in case of academic institution, 80% relaxation in the patent filing fees has been reduced. Then women applicant fast track patent filing process is there if there is a female applicant for patent. So basically, the filing process, which was tedious and which was not very much liked by the inventor, has the IPO office started making it a lot of easy, and the patent filing becomes very interesting. And of course, the small and medium scale enterprises started providing lot of scholarships, seed money funding basically to the startup inventors, so that they come up and file their patent. There is this provision of IP Mitra, which is again available on the IPO website, and then there is a small scale industries IP protection portal, which is also a scheme is there, SIPP. So even that scheme can be used by the inventors so that they can safeguard their patent rights. So lot of development has been taken place, and we can see that the patent filing has increased tremendously. Earlier it was very minimum, but now we have reached to a stage, wherein the patent filing uh, is quite significant. Now we are fifth in all over the world in filing the patent. So this is just because we have developed our patent law as per the contemporary needs of that whatever time it was, but we were developing our patent law as per the need of that time. So this is a very good reflection of that. But certainly there are certain challenges, and due to paucity of time, we will not be going into the details of these challenges, but I want you all to be aware about it. And the first of it is software patenting. As we know that Indian Patent Act does not allow software patent per se. It means that the software always needs to be there. In simple words, we can say that it has to be there in association with the hardware. Or for example, mobile application is there, then it will automatically, it will come with mobile, so then and then only a patent is granted. Exclusive patent protection to any code or software is not permitted in India. Now dabuse is a very recent case. Dabuse is an AI based device, for autonomous bootstrapping of unified sentience was developed. Many countries, for example, South Africa and Australia, provided patent to it, but the USPTO, the UK IP office, and the IP office in India outrightly reject this idea of providing patent to anything which has been generated by the like completely by the artificial intelligence. The only reason here is that because the definition of inventor as per the Indian Patent Act says that it has to be a natural person or a government organization, and AI so far is not included under the uh, understanding or under the definition of natural person in India. And because it is neither a natural person nor a government organization, WS was rejected. But South Africa and Australia government, they agreed and they provided patents to WS. Again, a very recent case was there using Chat GPT for drafting the patent claims. Of course, Chat GPT helped us in to a very great extent in enhancing our patent claims, but certainly they are not the alternative to patent agents or patent attorneys, because the amount of expertise, legal expertise, IP expertise, which can be enhanced with the help of attorneys, cannot be replaced with the Chat GPT. They can be used to assist, these drafting, but we cannot completely rely on Chat GPT to draft the patent claim, because that might reduce our chance to get the patent claim. But these are the things which are growing. So I think in the coming years, certainly for softwares and AI, the patent law in India will develop. They will have more clear precision, towards accommodating these new development. Because if we look back and see that the patent law in India was continuously developing according to the need of the hour. So in future also we will be very accommodating toward these changes. So with this, I want to thank you all for giving me this opportunity to discuss with you this. And if you have any query, you can just email me. This is my email address. And thank you once again. Thank you so much.